1 second, folks. Doesn't help. Oh well. We going? Are we live? I think we're live. Make sure that. Yep. Okay. Uh huh. Uh huh. Uh huh. Trying to remember. I guess. Sure. Whatever. All right. So here we go. A little theme music. All right, everybody. Welcome to this new playback thing. It seems pretty dang cool, and we're gonna keep on keeping on with it. So today we're reading from the Modern American Remedies book for the Modern American Remedies class, and we're reading a case today. I'll warn you, it's not the most interesting thing in the world unless you're kind of a laundered. And we're reading about preliminary or permanent relief today in a case called Coin Delaney Company versus Capital Development Board. It's a Seventh Circuit case from 1983. Actually, I lied. That's not where we're starting. Haha, my bad. Sorry, we're starting on Winter versus National Resources Defense Council Incorporated, a U.S. Supreme Court case from 2008. Obviously, much more interesting. All right. Starting off with the decision of the court. This case had complex facts and a complex procedural history. Active sonar, which bounces sound waves off objects in the water, is essential to the Navy's ability to detect enemy submarines. Training in the use of this sonar is therefore also essential, but active sonar sometimes injures protected marine animals. The extent and the significance of this injury was hotly disputed. The lower courts eventually entered a preliminary injunction that imposed conditions on the Navy's use of active sonar in training exercises off of Southern California. The impact of these conditions on the Navy's training exercises was also hotly disputed. The President and the Secretary of Defense exempted the Navy from some environmental statutes as they had the authority to do, but the National Environmental Policy Act, NEPA, which is 42 U.S.C. 4321, required the Navy to prepare an environmental impact statement, EIS, carefully addressing the environmental risks and any potential mitigation measures before deciding whether to continue with the training exercises or any other proposed action. The Navy's EIS would not be complete until the end of the training exercises. The justices' lengthy and conflicting opinions, or analysis rather, I guess on the opinions part, analyses of harm to marine animals, harm to the Navy, and whether anyone could exempt the Navy from a NEPA are omitted. So we have Chief Justice Roberts' opinion of the court. Starting in section 3, because our casebook admits stuff because they don't want us to know everything. Sucks, but whatever. All right, 3A. A plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits of the case and that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. The District Court and the Ninth Circuit concluded that plaintiffs have shown a likelihood of success on the merits of their NEPA claim. The Navy strongly disputes this determination. Let me check to make sure everything. Hopefully everyone can see and hear it's actually streaming. I think I have volume. Do I have volume? I don't know how to tell if I have volume. Freaking hope I have volume. All right. The District Court and the Ninth Circuit also held that what plaintiff demonstrates a strong likelihood of prevailing on the merits, a preliminary injunction may be entered based on a possibility of irreparable harm. The lower courts held that plaintiffs had met the standard because of scientific studies, declarations, and other evidence in the record established to a near certainty that the Navy's training exercises would cause irreparable harm to the environment. The Navy challenges these holdings, arguing that plaintiffs must demonstrate a likelihood of irreparable injury, not just a possibility, in order to obtain a preliminary relief. On the facts of this case, the Navy contends that plaintiffs' alleged injuries are too speculative to give rise to irreparable injury, given that ever since the Navy's training program began 40 years ago, there has been no documented case of sonar-related injury to any marine animal in Southern California. And even if sonar does cause a limited number of injuries to individual marine mammals, the Navy asserts that plaintiffs have failed to offer evidence of species-level harm that would adversely affect their scientific, recreational, and ecological interests. For their part, plaintiffs assert that they would prevail under any formulation of the irreparable injury standard because the district court found that they had established a near certainty of irreparable harm. We agree with the Navy that the Ninth Circuit's possibility standard is too lenient. Our frequently reiterated standard requires that plaintiffs seek preliminary relief to demonstrate that irreparable injury is likely in the absence of an injunction. Issuing a preliminary injunction based on the possibility of irreparable harm is inconsistent with our characterization of injunctive relief as an extraordinary remedy that may be only awarded upon a clear showing that the plaintiff is entitled to such relief. It is not clear that articulating the incorrect standard affected the Ninth Circuit's analysis of irreparable harm. Although the court referred to the possibility standard, it cited circuit precedent along the same lines. It affirmed the district court's conclusion that plaintiffs have established a near certainty of irreparable harm. At the same time, however, the nature of the district court's conclusion is itself unclear. The district court originally found irreparable harm from sonar training exercises generally, but by the time the district court's final decision came down, the Navy challenged only 2 of the 6 restrictions imposed by the court. The Navy did not reconsider the likelihood of irreparable harm in light of the 4 restrictions not challenged by the Navy. As explained in the next section, even if plaintiffs have shown irreparable injury from the Navy's training exercises, any such injury is outweighed by the public interest in the Navy's effective, realistic training of its sailors. A proper consideration of these factors alone requires denial of the requested injunctive relief. For the same reason, we do not address the lower court's holding that the plaintiffs have also established a likelihood of success on the merits. A preliminary injunction is an extraordinary remedy, never awarded as of right. In each case, courts, quote, must balance the competing claims of injury and must consider the effect on each party of the granting or withholding of the injunctive requested relief. It's quoting from Amico Production Company versus Gamble. The exercising the sound discretion, courts of equity should pay particular regard to the public consequences in employing the extraordinary remedy of an injunction. In this case, the district court and the Ninth Circuit significantly understand the burden the preliminary injunction would impose on the Navy's ability to conduct realistic training exercises, and the injunction's consequent adverse impact on the public interest of having a strong national defense. These interests must be weighed against the possible harm to the ecological, scientific, and recreational interests that are legitimately before the court. Plaintiffs have submitted declarations asserting that they take whale watching trips, observe marine mammals underwater, conduct scientific research on marine mammals, and photograph these animals in their natural habitats. Plaintiffs contend that the Navy's use of sonar will injure marine mammals or alter their behavioral patterns, impairing the plaintiff's ability to study and observe the animals. While we do not question the seriousness of these interests, we conclude that the balance of equities in consideration of the overall public interest in this case tips strongly in favor of the Navy. For the plaintiffs, the most serious possible injury would be harm to an unknown number of marine mammals that they study and observe. In contrast, forcing the Navy to deploy an inadequately trained anti-submarine force jeopardizes the safety of the entire U.S. fleet. Section 4. We do not address the underlying merits of the plaintiff's claims. While we have authority to proceed to such a decision at this point, doing so is not necessary here. At the same time, what we have said makes clear that it would be an abuse of discretion to enter a permanent injunction, after the final decision on the merits along the same lines as a preliminary injunction. An injunction is a matter of equitable discretion. It does not follow from success on the merits as a matter of course. The factors examined above, the balance of equities and the consideration of public interest, are pertinent in assessing the propriety of any injunctive relief, preliminary or permanent. The standard for a preliminary injunction is essentially the same as for a permanent injunction, with the exception that plaintiffs must show a likelihood of success on the merits rather than actually succeeding. Given that the ultimate legal claim is that the Navy must prepare an EIS, not that it must cease sonar training, there is no basis for enjoining such training in a matter credibly alleged to pose a serious threat to national security. A court concluding that the Navy is required to prepare an EIS has many remedial tools at its disposal, including declaratory relief or injunction tailored at the preparation of an EIS rather than the Navy's training in the interim. In the meantime, we see no basis for jeopardizing national security as the pertinent injunction does. Our analysis of the propriety of preliminary relief is applicable to any permanent injunction as well. The judgment of the Court of Appeals is reversed and the preliminary injunction is vacated to the extent that it has been challenged by the Navy. Now we have dissents. We have dissents from Justice Ginsburg and Justice Souter. If the Navy had completed the EIS before taking action, as NEPA instructs, the parties and the public could have benefited from the environmental analysis, and the Navy's training could have proceeded without being interrupted. Instead, the Navy acted first and thus thwarted the very purpose the EIS was intended to serve. I would hold that in imposing manageable measures to mitigate harm until completion of the EIS, the district court consciously balanced the equities and did not abuse its discretion. Section 3, because apparently we're skipping a bunch, okay. 3A from Ginsburg's dissent. Flexibility is a hallmark of equity jurisdiction. The essence of equity jurisdiction has been the power of the chancellor to do equity and to mold each decree to the necessities of the particular case. Flexibility rather than rigidity has distinguished it. Consistent with equity's character, courts do not insist that litigants uniformly show a particular predetermined quantum of probable success or injury before awarding equitable relief. Instead, courts have evaluated claims for equitable relief on a sliding scale, sometimes awarding relief based on a lower likelihood of harm than when the likelihood of success is very high. This court has never rejected that formulation, and I do not believe it does so today. Equity's flexibility is important in the NEPA and EPA context. Because an EIS is a tool for uncovering environmental harm, environmental plaintiffs may often rely more heavily on the probability of their success than on the likelihood of harm. The court is correct that relief is not warranted simply to prevent the possibility of some remote future injury. However, the injury need not have been inflicted when application is made or be certain to occur. A strong threat of irreparable injury before trial is an adequate basis. Then Section B. In light of the likely substantial harm to the environment, NRDC's almost inevitable success on the merits of its claims that NEPA required the Navy to prepare an EIS, the history of this litigation, and the public interest, I cannot agree that the mitigation measures the district court imposed signal an abuse of discretion. Environmental injury by its nature can seldom be adequately remedied by money damages and is often permanent or at least of long duration, i.e. irreparable. If such injury is sufficiently likely, therefore, the balance of harms will usually favor the issuance of an injunction to protect the environment. For the reasons stated, I would affirm the judgment of the Ninth Circuit. Justice Breyer, joined by Justice Stevens, dissented in part that they've omitted that opinion from the book. All right, well, that was a very interesting first case today. All right, so the second case is the one I already mentioned that I was doing first, but not. So, hey, let me check whether here, since it's my first time on here. Let me see if the other streams are up and working. Let's see here. Make sure they're working. Don't know. Charging my attack. Let's see. Let's see if the mod on YouTube says anything. Hope so. Yay, it's working. Hooray. All right. Well, I will go back to the other place. Do the second case. All right. So here we go. Okay, ready for the second case now. Coy Delaney Company versus Capital Development Board. 7th Circuit case from 1983. And we're talking about preliminary or permanent injunctive relief is the topic of this section of the book. All right. The state's Capital Development Board led a contractor to replace the plumbing fixes in a state prison. Cone Delaney got the subcontract for toilet flush valves in the first phase of the project. Cone Delaney's valves malfunctioned, were replaced, and again malfunctioned. When the board announced bidding specifications for the second phase of the project, it required that all bidders to use Cone Delaney's main competitor. Before Judge Eschelbaugh, Judge Posner, circuit judges, and Judge Dumbald, that's a great judge name, senior district judge, Posner writes the opinion. Bids were received, but on May 7th of 1979, 2 days before they were to be opened, Cone Delaney sued the board under 14 U.S.C. 1983. That is a civil rights violation claim. And on May 8th, it obtained a temporary restraining order against the board's opening the bids. The state asked that Cone Delaney be ordered to post a $50,000 bond, pointing out that the temporary restraining order was preventing it from proceeding with the entire project and that the indefinite delay could be extremely costly. But Judge Perry, the emergency motions judge, required a bond of only $5,000 in the belief that the temporary restraining order would be in effect for only a week until Judge Bua, Bua, could hear the motion for the preliminary injunction. However, at the preliminary injunction hearing, Judge Bua issued the injunction but refused to increase the bond. The parties stipulated that, quote, the bond was continued for the preliminary injunction. Cone Delaney's premise was that under Poviland versus Pecorius, a Appellate Third Circuit case from 78, Cone Delaney had a property right of which it was deprived without due process of law. Judge Boya said that Cone Delaney was likely to prevail on its merits. But Poviland was reversed by the Illinois Supreme Court in 79 after Judge Bua had granted the preliminary injunction. Oh, this is a mess. When they held then that under Illinois law, a bidder has no property right in being allowed to bid on a public contract and that Cone Delaney therefore had no claim. So the procedural posture here, right? These people are making really crappy valves for toilet seats in prisons. And they malfunction once, they have to remove them as they're trying to build out the toilets in this prison system. And they malfunction again. And so they're like, you know what, Cone Delaney, you make sucky products. We're not using you. Anybody who wants, okay, they have a competitor, we're going to give the bid to you. And then Cone Delaney says, we want money because you're hurting our business because you chose them over us. The judge gives the injunction, puts a bond at $50,000, and then they have a hearing on it. Cone Delaney, the judge drops it to $5,000, and then the judge issues the injunction. But right after the judge does that, the Supreme Court hears a case and passes a case. Okay, here's a case and passes a case, right? And that case says, guess what? The kind of injunctions you issued for money damages under 42 1983 claim, you can't get those. So now the judge has just issued an injunction that has now been declared unconstitutional by the Supreme Court. I have the volume control on the thing too. Is that better? Is it louder better, or is it too loud? Was it too loud or what? Is it better now? Better now? How the hell is it better? I turned the volume down. Better now? Yo, Lehu. There's no way it's the same. I've reduced the volume. There's no way. I guess it's just loud. I don't know what to tell you. I mean, I don't want to tell you. Okay, I'll try to read more quietly, I guess. So they held that under Illinois law, a bidder has no property right in being allowed to bid on a public contract, and that Cone Delaney therefore had no claim. Our decision came down on February 22nd, 1980, and the board at last opened the bids. The low bid was $214,000, but it was conditioned on a deadline that had already expired. The board rebid the project, and this time the low bid was $270,000. The board then joined Hanover Insurance Company, the surety on the injunction bond, as an additional defendant in Cone Delaney's civil rights suit pursuant to Federal Rule 65.1, and moved the district court to award the board damages of $56,000 for the wrongfully issued preliminary injunction. Judge Bua refused to award damages. His opinion states, quote, it would be unreasonable to require a party to anticipate a change in the law, end quote. Although the district court has unquestioned power in an appropriate case, not to award damages on an injunction bond, even though the grant of the injunction was reversed, the district court's opinion suggests that the court may have believed it had to deny damages because the lawsuit had not been brought in bad faith and was not frivolous. This would be the proper standard if the question were whether to award a prevailing defendant his attorney fees. Rule 65C in Federal Rules of Civil Procedures requires a plaintiff who gets a preliminary injunction to post a bond, quote, for the payment of such costs and damages as may be incurred or suffered by any party who is found to have been wrongfully enjoined or restrained, end quote. The court is not told in so many words to order the applicant to pay the wrongfully enjoined party's damages, but it is told to require a bond or equivalent security in order to ensure that the plaintiff will be able to pay off all or at least some of the damages that the defendant incurs from the preliminary injunction, if it turns out to have been wrongfully issued. The draftsman must have intended that which such damages were incurred to the plaintiff or his surety would normally be required to pay the damages at least up to the limits of the bond. Yet some courts treat the district court's discretion to award or deny damages under an injunction bond as completely open-ended unless the plaintiff acted in bad faith in seeking the preliminary injunction. Those cases dismiss Rule 65C's requirement of a bond or other security by pointing out that the district court can require a bond of nominal amount in appropriate cases, for example, if the plaintiff is indigent. But it is one thing to say that the requirement of a bond can in effect be waived where there is a good reason for doing so, a dispensation narrowly construed in the circuit, and another to say that where a substantial bond is clearly required by the equities of the case, the district court will nevertheless has carte blanche, that is unlimited power, literally a blank card, to excuse the plaintiff from paying any damages on the bond. Most cases hold that a prevailing defendant is entitled to damages on the injunction bond unless there is a good reason for not requiring the plaintiff to pay in the particular case. We agree that with the majority approach, not only is it implied by the text of Rule 65C, but it makes the law more predictable and discourages the seeking of preliminary injunctions on flimsy, though not necessarily frivolous grounds. When rules prescribe a course of action as the norm but allow the district court to deviate from it, the court's discretion is more limited than it would be if the rules were non-directive. Rule 65C establishes what Judge Friendly recently called a judicial principle for preference guiding the exercise of the judicial district judge's discretion. Yeah, a lot of D's there. Henry J. Friendly's Indiscretion About Discretion. Yeah, and Emory Law Journal. There you go. The judge must have had a good reason for departing from such a principle in a particular case. It is not a sufficient reason for denying costs or damages on injunction bond that the suit has had in the case been brought in good faith. That would not be sufficient only if the presumption were against rather than in favor of awarding damages on the bond. The award of damages on the bond is not punitive, it's compensatory. A good reason for not awarding such damages would be that the defendant had failed to mitigate damages. A good reason, not for denying but for awarding damages in this case, would be that the bond covered only a small fraction of the defendant's damages. Nor could $5,000 be regarded as excessive because the plaintiff was a poor person. The plaintiff is a substantial corporation. The district court did allude to one factor besides mere absence of bad faith that supported its ruling: the challenge in the applicable law after the preliminary injunction was issued. Intermediate state appellate courts' decisions are reversed with the same frequency. We do not believe that a change in the law is always good ground for denying costs and injunction damages to a prevailing party, but it is a legitimate consideration, perhaps especially where the prevailing party is a state agency that benefited from a change in the law of the state. In any event, a remand is necessary to allow Judge Bua to consider and weigh all the relevant factors identified in this opinion, bearing in mind the principle of preference that we have indicated should guide his equitable determination. It remains to consider whether on remand the board should be allowed to seek injunction damages above the limit of the bond. The surety cannot be required to pay more than the face amount of the bond, but it is a separate question whether the plaintiff can be. However, the Ninth Circuit has held in scholarly opinion that the bond is the limit of the damages the defendant can claim for a wrongful injunction, even from the plaintiff's provided the plaintiff was acting in good faith, which is not in question here. Another exception might be that where the plaintiff was seeking restitution rather than damages. The Supreme Court has cited buddy systems in dictum for the proposition that, quote, a party injured by the issuance of an injunctive injunction rather, issuance of an injunction later determined to be erroneous has no action for damages in the abuse of a bond, citing W.R. Grace and Company versus Local Union 759 United Rubber Workers. In asking for more than the amount of the bond, the board is necessarily relying not on the bond but on some principle of equity that Grace says does not exist. The preliminary injunction in this case halted work on a major construction project for a year. It could easily have been 2 or 3 years, and the expense imposed on the defendant not $56,000 but $560,000. It might be a good, very good boon to the legal system of this country to discourage injunction suits by putting plaintiffs at such risk. But we do not see how such an approach can be squared with the general attitude towards litigation implied by the American rule, that each side must pay its own way and bear its own lawyer's costs. Having to post bond is a detriment just to plaintiffs. But if the plaintiff's damages are limited to the amount of the bond, at least he knows just what his exposure is when the bond is set by a district court. A defendant dissatisfied with the amount of a bond can, on appeal from the preliminary injunction, ask the Court of Appeals to increase the bond, which the defendant here did not do, reversed and remanded. Oh, because it's here. See, is it full screen now? Is the whole thing full screen now? Oh, there's a way to fix that. Hang on. That's not it. That's not it. There's a way to do that. There's a way to fucking do it. I'll watch a little tutorial on it. Nope. I know, babe. I tracked myself off stage on purpose to try to figure out how to. There's a way to do it. Oh well. I'll deal with it later. Go back away from me. Wait, how the hell did that happen? All right. Well, I'm gonna end the stream, everybody. I'll try to figure it out before next time. Hopefully, we'll do better. I'll do another stream in a little bit here for conflicts of law reading. It'll be more boring. So talk to you soon. Toodles.